Good day, everyone. Today we will be reporting on Chapter 7, Extinguishment of Sale, focusing on its causes and the concepts of conventional and legal redemption. Under Article 1600, a sale is extinguished by the same causes as all other obligations by those stated in the preceding articles and by conventional or legal redemption. Causes of the extinguishment of sale. Sales can be extinguished by causes common to all obligations, such as payment or performance, loss of the thing due, condonation or remission, confusion or merger of rights, compensation, evasion, rescission, resolution of hidden defects, legal redemption, and conventional redemption. Once extinguished, ownership returns to the vendor or the contract is undone depending on the cause. Article 1601 Conventional redemption occurs when the vendor reserves the right to repurchase the thing sold, subject to compliance with Article 1616 and any stipulation. So, what is conventional redemption? It is the seller's right to recover the property provided he reimburses the buyer. Number one, the price of the sale. Second would be expenses of the contract. Third is legitimate payments and necessary and useful expenses. The purpose allows vendor to recover things sold after receiving money, temporarily often used as security. Article 1602 Equitable Mortgage Presumptions. A contract is presumed an equitable mortgage if 1. Price is unusually inadequate, vendor remains in possession, if there is an extension of redemption period, buyer retains part of purchase price, if vendor pays taxes, and any case showing intention to secure a debt. If a contract is presumed to be an equitable mortgage, these are the legal consequences. Number one is that the contract is treated as a mortgage and not a sale, and consequently, the buyer cannot consolidate ownership of the property because it is only considered security for a debt. And finally, any payments stipulated as rent paid by the seller remaining in possession are treated as interest on the loan, making the transaction subject to the usury law. So, if this presumption is triggered, the burden of proof shifts, requiring the buyer or vendee to rebut the presumption with clear evidence that the contract was actually intended as a true sale. Article 1603 Tout construed as mortgage. This article establishes a rule of interpretation favoring the vendor when a contract's true nature is unclear. So, in case of doubt, a contract that appears to be a sale with the right to repurchase shall be construed as an equitable mortgage. So, this rule is a principle of statutory construction intended to protect vendors from oppressive forfeiture. So courts view the pacto de retro sale with suspicion because of its potential for abuse. Therefore, if ambiguity exists, the contract will be declared a mortgage. Article 1604 absolute sales also covers. So this applies also to absolute sales. This article extends the legal presumption of an equitable mortgage to contracts that purport to be an absolute sale. So, this means even if a contract is labeled an absolute sale, the courts will look at the intention but not the form. So, this protects owners from disguise loans. Article 1605 or reformation. So, vendor may ask for reformation of instrument. This article grants the apparent vendor or the seller the right to ask for reformation of the instrument in the cases mentioned in Articles 1602 and 1604. Reformation is allowed when the written contract does not express the true intentions of the parties, which was a mortgage and not a sale. So this action converts the document to reflect the real agreement. Article 1606 Redemption Period. The default period is 4 years from contract, or if there is no agreement, it should be 4 years. If with agreement, not more than 10 years. Vendor may still redeem within 30 days after final judgment if the issue involves determining whether the contract was truly a sale with the right to repurchase. Article 1607 or judicial consolidation. This article is a legal protection for the seller in the sale with the right to repurchase or pacto de retro, particularly when the property is of real property. So it mandates that if the vendor fails to repurchase the property by returning the funds required by Article 1616, the buyer cannot automatically record the consolidation of full ownership in the registry of property. So the vendee must first secure a judicial order, and this process requires that the vendor be duly heard in court, ensuring that the contract is proven to be a true sale, not an equitable mortgage, and preventing the abusive forfeiture of the property. Article 1608 Redemption against successors. This article establishes that the vendor can enforce the right of conventional redemption against any possessor who acquired the property from the original buyer, regardless of subsequent transfer. So, this right of redemption is a real right that follows the property, making it binding even if subsequent contracts made no mention of the right to repurchase. And this right is subject to the protections provided by the mortgage law and the land registration law for innocent purchasers for value. Article 1609 Subrogation of Rights. Article 1609 clarifies that the vendee, while in possession of the property, is subrogated to all the vendor's rights and actions concerning the property. So, this means that the vendee acquires all the warranties and the right to file legal actions against third persons. And the vendee effectively holds the equivalent of full ownership, subject only to the potential exercise of the redemption right by the vendor. Article 1610 Creditors Redemption. This article provides a key limitation on the vendor's creditors when attempting to exercise the right of conventional redemption. So, the creditors of the vendor cannot make use of the right of redemption against the vendee until after they have exhausted the property of the vendor. So, this action by the creditor is subrogatory action, and the creditors step into the shoes of the vendor to exercise the right that the vendor himself neglected or refused to do. So the core requirement is that the creditors must first exhaust the other assets or properties of the vendor, and they can only pursue the redemption right if the vendor is insolvent or their other assets are insufficient to cover the debt. Any successful redemption ultimately benefits the creditors as the recovered property becomes part of the vendor's assets, which can then be used to satisfy the outstanding debts. Articles 1611 to 1615. These articles govern situations involving co-owners and heirs. This article addresses a specific scenario involving the repurchase of an undivided immovable property, granting the buyer the power to demand the repurchase of the entire property under certain conditions. So, this rule is a constraint on the original seller's right to partially redeem the property. And the purpose of this article ensures stability in co owned property and prevents the inconvenience of the vendee having to deal with fragmented ownership if the vendor could redeem only a small portion. Article 1612 Redemption by co vendors and heirs. This provision establishes the principle of proportional redemption when multiple parties are involved in a sale with the right to repurchase, whether as original co vendors or as heirs of a single vendor. So, this means that the right to redeem is indivisible in its exercise only to the extent of the vendor's original share. Article 1613, vendee cannot be forced into partial redemption. This article grants the vendee a powerful defense against fragmented ownership when multiple co-vendors or co-heirs are involved in the repurchase. So this rule essentially says that the vendee cannot be forced to accept a partial redemption if the vendors cannot agree to redeem the entire property. So the vendee may demand of all the original sellers or co-heirs that they come to an agreement upon the repurchase of the whole thing sold. If the vendor or co-heirs fail to reach an agreement on redeeming the entire property, the vendee cannot be compelled to consent to a partial redemption. So this provision's primary purpose is to prevent the inconvenience of fragmented ownership, to protect the acquisitive value of the property of the vendee. So it ensures the vendee can either transfer the whole property back or keep it intact. Article 1614, Independent Redemption by Co-Owners. This article affirms the right of a co-owner to individually redeem only the share they sold, protecting them from being forced to buy back the entire property. So each co-owner of an undivided immovable who sold their share separately may independently exercise the right of repurchase as regards only their own share. The buyer cannot compel the co-owner to redeem the entire property. So this prevents the inconvenience of fragmented ownership for the co-owner and respects their right to recover only their sold portion. This rule is actually in contrast with Article 1613, where the vendee can demand agreement on the whole property when shares were sold jointly in the same contract. Article 1615, Redemption versus Heirs of Vendee. This article explains the procedure for exercising the right of redemption when the buyer dies and the property passes to multiple heirs. So, as a general rule, if the vendee leaves several heirs, the original seller can only bring the action for redemption against each heir for his or her own share. So, this rule applies regardless of whether the property remains undivided or has already been partitioned among them. If the inheritance has been divided and the sole property has been awarded wholly to one of the heirs, the action for redemption may be instituted against the single heir for the whole property. So, this provision prevents the vendor from compelling one heir to shoulder the burden of the entire redemption when the property has been split proportionally, while allowing for redemption of the whole if the properties entirely was assigned to a single heir. Article 1616, or requirements for redemption. This article outlines the mandatory obligations the vendee must fulfill to successfully exercise the right of conventional repurchase. To repurchase the property, the vendee cannot simply avail himself of the right without returning to the vendee the following items, like the price of the sale. And in addition to the price, the vendor must return the expenses of the contract and any other legitimate payments made by the reason of the sale, the necessary and useful expenses made on the things sold. So these payments must be made to the vendee concurrently with exercising the right of redemption. Article 1617, Fruits. This article governs how fruits growing on land are treated at the time of redemption. So if the purchaser did not pay indemnity for the fruits existed at the time of the sale, there shall be no reimbursement of those fruits existed at the time of redemption. If there were no fruits at the time of the sale, but some exist at the time of redemption, they shall be prorated between the vendor and the vendee. So the vendee is given portion corresponding to the time he possessed the land in the last year, counted from the anniversary of the date of the sale. Article 1618, Leases and Charges. So this article explains the condition of the property once the vendor successfully exercises the right of conventional redemption, or if the vendor recovers the property free from charges but must respect good faith leases made by the buyer. So the vendor who repurchases the property receives it back with the following effects regarding encumbrances. So free from charges and mortgages. So the property is received free from all charges or mortgages constituted by the vendees or any such encumbrances placed on the property by the buyer while they owned it are extinguished upon redemption. And respect good faith leases. The vendor must respect the leases with the vendee may have executed. So this exception applies only if the leases were executed in good faith and in accordance with the custom of the place where the land is situated. Article 1619, Legal Redemption Defined. Legal redemption is the statutory right to be subrogated in the place of the buyer. So this allows a third party to acquire the property under the same terms and conditions stipulated in the original contract. So this applies when ownership is transferred through purchase or the Sean in payment or any other transaction by owner's title. Article 1620, Co-owner Redemption. A co-owner has the right of redemption if the share of another co-owner is sold to a person. So if the sale price is grossly excessive, the redeeming co-owner only has to pay a reasonable price. If two or more co-owners want to exercise the right, they may only do so in proportion to their respective shares in the common property. Article 1621, Rural Adjoining. The owners of adjoining lands can also exercise the right of redemption under specific conditions designed to promote agricultural efficiency. So the land sold must be rural land and its area must not exceed 1 hectare. So this right is not applicable if the buyer does not own any other rural land. And the right is also not applicable when the lands are separated by brooks, drains, roads, or similar visible boundaries. If multiple adjoining owners seek redemption, the owner of the adjoining land with the smaller area has priority. If the areas are equal, so the one who first requested redemption has priority. Article 1622 or urban preemption. This article grants the owner of an adjoining lot the right of preemption or redemption for urban land under strict conditions aimed at preventing speculation and promoting practical use. So the land must meet these requirements. Number one, it is urban land. It is so small and so situated that a major portion cannot be used for any practical purpose, and it was bought merely for speculation. So, right of preemption, this right is exercised before the resale is perfected. Right of redemption, this means that this right is exercised after the resale has been perfected. Price must be reasonable, not necessarily identical to the speculative price. So this means that the adjoining owner has the right to acquire the land at a reasonable price, which is not necessarily identical to the speculative price. And when two or more owners of adjoining land seek to exercise the right, preference goes to the owner whose intended use of the land in question appears best justified. Article 1623 or 30-day notice requirement. This article establishes the mandatory procedure and prescriptive period for exercising legal redemption. So the right of legal preemption and redemption must be exercised within 30 days, and this period begins only upon written notice by the prospective vendor or the vendor as the case may be. So this written notice must be personal and actual, and the deed of sale shall not be recorded in the registry of property unless it is accompanied by an affidavit of vendor stating that written notice has been given to all possible redemptioners. So the priority rule, The right of redemption of co-owners excludes that of adjoining owners. So this means co-owners have priority over adjoining landowners when both rights exist over the same land. That's the end of our report. We hope this presentation has clearly outlined the key causes for the extinguishment of a contract of sale, emphasizing the important distinction between conventional redemption and legal redemption. Understanding the strict periods, the legal presumptions regarding the equitable mortgage, and the specific obligations of both the vendor and vendee is crucial to navigating the law on sales. So, thank you for your time and attention.